Yes, Mr. PP.
My lord, regarding Moinuddin, Moinuddin is present along with the chief LADC.
Just a minute. Moinuddin was present on the last occasion also?
Yeah.
Yes. What about the death certificate or regarding Moina?
My
Moina?
lord, regarding the death certificate of Balaimia, it is reported that the original birth certificate is not found in his
Not
house.
birth certificate.
Death certificate.
Sorry, death certificate. But one report has been submitted by the Dr. Abu Saleh Enu Borbuya, that is the in charge of Kalinagar BHC, regarding the authenticity of the death certificate, and in his report he has enclosed one online death certificate, and details he has stated that this birth certificate has been issued from the death certificate has been issued from the authority, and for it is issued and is verified by me and found correct. He has submitted the report.
No, why the original could not be produced?
Original death certificate is not found in the house of the accused person.
When did he pass away?
He passed away on on 16/9/2017.
17.
17.
Mr. Chaudhary, you are not aware of that? 16/9, okay. And what about the report on the other accused convicts?
Regarding the other accused, my lord, the OC is present, submitted report that in several times he had attempted but not found in his house, in their house.
In that case, what is the recourse available, Mr. PP?
Pardon you, regarding
in that case, in such a situation, what is the recourse available to the court?
PNA.
No, PNA is for the others. What about the sentence for the accused convict who is present in the court? Yes, what is your take? What is the provision which will help us in situation of this kind? This is not a very unique situation. It happens.
Yeah.
Mr. Chaudhary? Yes. Conviction is given by this court in a state appeal.
In a state appeal.
The acquittal has been reversed. Now we have pronounced the judgment. Now we have given a date for sentence hearing. In accordance with law, we have to give sentence hearing. Sentence hearing only out of 4 persons, 4 convicts. One has been stated to have been passed away. One is present. And 2 they could not be found. They are absconding. So far as the absconding persons are concerned, we have the mechanism, what we can do. We can issue PNA, whatever is it. And but so far as the person who has surrendered or who has been produced, can a sentence be passed? Split sentence, if yes, under what provision?
That pilot accused has to be heard, madam.
No, we have already heard him.
Yeah.
Sentence hearing, he is present, he has said. And we have also taken the assistance of Mr. Chaudhary. In fact, we can give some more time to Mr. Chaudhary. He is the counsel, but he is not in touch with the clients, obviously, for obvious reasons. Appeal is of the year 2010. Yeah. He was not even aware that one of his clients had passed away in the meantime, in 17. One convict is there. We have given the facility of online. No point coming from Karimganj to Guwahati. He is there, he's been produced. Split judgment can be passed, but can a split sentence be passed? Madam?
Okay. Uh, Since the other two convicts are not appearing before the learned court below, Lordship may pass appropriate orders in that regard. the Lordship.
Under what provision?
Power
Tell us.
calculate code.
This is not an equity code, we
My
go by
lord.
the code. If you see, Mr. Chaudhary and Madam,
My lord,
if you see the judgment under the CRPC in chapter 27,
my lord,
353, section 353, if you come to subsection 6 proviso,
352. 352.
353, subsection 6 proviso,
yes, my lord.
provided
If the accused
that,
is not-
please read,
352.
If the accused is not in custody, he shall be required by the court to attend to hear the judgment pronounced, except where his personal attendance during the trial has been dispensed with, and the sentence is one of fine only, or he is acquitted. Provided that where there are more accused than one, and one or more of them do not attend the court on the date on which the judgment is to be pronounced, the presiding officer may, in order to avoid undue delay in the disposal of the case, pronounce a judgment notwithstanding their absence.
so this is pertaining to the judgment.
Judgment.
We are on the aspect of sentence hearing.
Yes, my lord.
Will it also cover the aspect of sentence hearing? Judgment we have already pronounced in,
Yes.
in their absence. We are not too concerned.
He can try to provide it.
Because he gets it quite
Hmm.
Yeah.
Hmm.
it's quite tense. He has the judgment.
The absence of fear of the accused will not be a deterrence for passing the judgment,
That's
which we have already done.
My lord.
Now, so far as sentence hearing is concerned, without hearing them,
Accused
giving a
person that
sentence will not be proper. But at the same time, we cannot be held helpless. We can issue PNA, whatever. But the accused who has, convict who has appeared before us,
Well.
he is been kept in custody. Now-
Matter once sentences are taken to speak, unless this is a bail level offense or a small petty offense, he will be in the custody. So
No, no, this is-
judgment
this-
follows
no.
automatically.
No, this is not a matter of being in custody. See, you have come, they have come against an order of acquittal.
Yes.
He was never in custody in the meantime. When we heard the matter, when we come to a conclusion that yes, this is a matter of conviction, we passed the order of conviction. Judgment has been passed. Now, the conviction has to be now followed by a procedure of sentence hearing. We are only on that part. And this is not on the way that I am not guilty, I was not. It is only on the quantum, how much sentence,
Yes.
what do you have to say anything on the sentence? This is the minimum, this is the maximum, what do you have to say? That we can give you an opportunity. In fact, we have given an opportunity, but two of them are not appearing. So what do you do at that stage?
Issue, my lord. Maybe 2 days, my lord.
No,
Just
this
to
is,
see the law.
no, we want to go by the correct procedure.
Yes, exactly.
It's not that,
Exactly. Whatever I say, that is what may not be correct.
whatever, because apart from this proviso to subsection 6,
Yes.
I do not find anything else.
Yes. Yes.
But if we only have to
Yes,
see
this
whether
is only-
this
this is
proviso
only that.
also takes into its ambit the part of sentence hearing.
Yes.
Because this is only on the judgment part.
Right.
353.
386. 386.
Very true.
Hmm.
I think the sentence was more than one case.
3?
386 is the
86.
power of the appellate court,
Appellate
my lord.
Yes.
What the appellate court
Yeah.
can do, my lord.
No, we have already done. We have
Well-
reversed. Everything has been done. Enhanced what? Now the sentence hearing, but because we almost act as the trial court, while it's for the first time that we are convicting. And once we convict, the necessity of giving a sentence hearing is there.
Yeah.
We cannot just overcome it. That will not be in accordance with law.
This is the 389.
Okay, we'll fix another date.
Yes, they have to
Kindly
do
go
more.
through it. Mr. Chaudhary, you can kindly assist us.
Yes.
If you can find any provision or some case law on this proviso,
Fine.
Case law will
on this
be-
proviso, explaining this proviso, and we'd pass an order. And so far as the absconders, what do you do?
Lordship, PNB issued, I am not aware of whether the last occasion,
No, we have
available
not-
warrant of arrest.
Yes, yes.
No, no,
NBW.
that NBW is
Already
in
done.
Already there.
execution. That was reissued last time.
My lord.
They have not been able to.
Report to.
Yes, what is the report?
Ah,
Apnaloke agot ahok.
Report. রিপোর্টটা কি হচ্ছে
নাই গৈছিলে না আপোনালোকে কেতিয়া গৈছিলে কোন তাৰিখে গৈছিলে ক'ত গৈছিলে
ঘৰত যোৱা হৈছিলে 20 তাৰিখে যোৱা হৈছিলে স্যাৰ আৰু তাৰ
কোন
আগত
তাৰিখে গৈছিলে
20 তাৰিখে স্যাৰ
20 কি 20 মাৰ্চ
হয় স্যাৰ
20 মাৰ্চৰ 3 দিন আগতে
হয়
আগৰ অৰ্ডাৰটো 17 মাৰ্চৰ আছিল নহয় 20 মাৰ্চত গ'ল নাপালে
হয় স্যাৰ
তাৰপিছত
22 যোৱা হৈছে
ক'ত
স্যাৰ
গৈছিলে ঘৰত গৈছিলে
ঘৰত গৈছিল স্যাৰ
কাৰ ঘৰত
আসামি ঘৰ আব্দুল
হা আছিক
মালিক
কোনজন
আব্দুল মালিক
আব্দুল মালিক A4 নাপালে
হয় স্যাৰ
ফুটা পোছা কৰিলে ফেমিলি মেম্বাৰে কি ক'লে পৰিবাৰে
বাৰটো কয় বাহিৰত আছে কেতিয়াবা কয় নাজানো স্যাৰ তেওঁলোকৰ মানে লৰাই কয় নাজানো আৰু ফেমিলি মেম্বাৰে কয় বাহিৰত গৈছে তেনেকাও কয় স্যাৰ কিন্তু ক'ত আছে কথা একো নকয়
এই আছিক আলি তেখেতৰ
স্যার আজিকালি ঘৰত মই 20 তাৰিখ গৈছিলো
20 তাৰিখ
হয় স্যাৰ
কি পালে
স্পন্ডিং হৈ আছে স্যাৰ তাৰ
এবস্কন্ডিংটো জানোৱে কৈছে কাক সুধিলে কাক সোধা পোছা কৰিলে ঘৰটো ক'ত তেখেতৰ
ঘৰত ৰাজধান স্যাৰ একদম পইণ্ট স্যাৰ
কাক পালে তাতে
তাত ফেমিলি মেম্বাৰ কোনো নাই তাৰ লগৰ ওচৰত এজন ঘৰৰ মানুহ আছে তাত তেওঁলোকে ক'ব নোৱাৰে তাত
Okay, we'll defer this for some time and we'll pass appropriate orders on this to absconding accused. On a standing warrant as well as issuance of PNA.
Yep.
When can we come back? And this, so far
This
as,
issue, my lord, on Thursday, issue on Saturday.
Moinuddin is concerned, he'll be in custody till then.
My lord.
Third, Miss B. Bhuya, learned APP for the state, also has Sri A. Chaudhary, learned counsel for the respondents. Para, Sri Devajyoti Roy,
দেবজ্যোতি রায়
Devajyoti Roy, learned PP Karimganj,
পার্ডন ইউর এডিশনাল টিভি
additional PP Karimganj. He is also present via video conference. Full stop.
Lordship, I'm sorry to interfere regarding the death certificate which could not be produced by the parties concerned, my lord. Lordship, can an enquiry be made, my lord, because
Police has made an inquiry. Would like to have. আপোনালোকে এখেতৰ ঘৰত গৈছিল নেকি যোন ঢুকুৱা বুলি কৈছে মইনা মিয়া বলাই মিয়া মনাই মিয়া বলাই মিয়া এখেত নহয় এখেতটো প্ৰেজেণ্ট মইনুদ্দিনৰ কথা কোৱা নাই যোন ঢুকুৱা বুলি কৈছে
বলাই মিয়া
ঘৰত গৈছিলে তেখেতৰ
বলাই মিয়া
কি পালে
জেৰেক্স কপি এটা পাইছো জেৰেক্স কপি এটা পাইছো অৰিজিনেলটো হাৰিলে বুলি ক'লে আৰু জেৰেক্স কপিটো লৈ আহি তাৰপিছত মেডিকেলৰ ছাৰৰ তাতে লেটাৰ দিলে আমাৰ ICC
One doctor has given some certificate. We do not
that
know.
will not, it should be under registration of birth and death.
No, that certificate was given, but the original is missing, they have said. Xerox is there, and so far as the Xerox copy is concerned, one doctor has certified that Xerox to be a correct one. Now, that may not be conclusive. We'll not say much.
My lord,
We'll not say much. We'll decide on the next day.
my
Kindly,
lord.
kindly assist this court on all the aspects. কি করলো last up? APP, a present by video conference. The officers of the concerned PS are also present, and they have produced the respond number 3, Moinuddin. Full stop. As regards the direction of this court on 17/3/2025 regarding production of the original death certificate, so far as accused number, respond number 2, Bolai Mia, alias Monai Mia is concerned, comma, that has been stated to be not available. Full stop. However, the certificate has been sought to be verified, has been stated to be verified. By whom?
By Dr. Abu Saleh Enu Borbuya,
Who is he?
in charge of Kalinagar BPHC.
In charge of Kalinagar?
BPHC.
Okay. The officers of the concerned PS have, however, informed that visits to the houses of accused number of respond number 1 and 4, namely Ashik, Ali, and so and so, and Abdul Malik, were made on 23/2025, and their whereabouts could not be ascertained. Full stop. Sarah? On the aspect of the further course of action touching upon the passing a split sentence for the aspirant number 3 who is present, comma, this court has requested Sri Chaudhary, B.M. Chaudhary, learned counsel, to offer his assistance as an amicus. Full stop. List this matter for consideration. When? On?
27th of Thursday.
Is it okay, Mr. Chaudhary? On 27th, full stop. The order pertaining to issuance of NBWA would be operative till further orders are passed. Okay, we'll meet on 27th. The accused number, the respondent number 3, be kept into custody until further orders. Okay, brother?
Okay, bro.
Yes, can be done.
Deeply obliged.
May I please?
Yes, just a minute, please. Yes.
First, I recommend item number 11, ma'am, on behalf of Mr. A.R., who is appointed as amicus curiae.
Yes. Hmm.
Kindly attend the matter of the day, ma'am.
Other side informed.
Other side, sir.
I think it's a POXO matter. K. Fukan is there. Miss K. Fukan. Please inform her. We'll allow your prayer.
Okay.
First you inform her, then you come back to us, okay?
Okay.
Yes.
Yes, Your Lordship, I beg to mention item number 2 and 3, Lord. Will be listed after 2 weeks. My senior has some personal problem today, Lord.
2 and 3, madam. On a request made on behalf of the appellants, matters are adjourned to be listed after 2 weeks. 2 and 3. Yes. Family court and conduct, private labor, family court and conduct. Madam, what happened? File to the local. Yes,
Lordship, on the last question, Lordship pointed out that Lordship, it is not negligible the present conflict. Interlocutory order,
yes.
Lordship. I am thankful to your Lordship. I
You
was not
withdraw
aware.
this file or revision?
Lordship, Lordship, with liberty, Lordship, I am with you. I was also not aware. I am thankful to you.
But where is that order we had passed? Did we pass any order?
No.
order is passed. That was in IMI.
That was in I,
Oh, in
Lordship.
the
Yeah,
condonation
Lordship.
petition?
Yes,
Condonation
Okay,
petition.
okay. Heard Sri M. Bhagavati, learned counsel for the appellant, as well as Sri J. Payang, learned counsel for the
Yes.
respondent.
Correct.
Full stop, para. At the outset, Sri Bhagavati, the learned counsel, has submitted that by inadvertence, the challenge to the impugned order has been made by way of an appeal, which may not be maintainable, as the order is of interlocutory nature. Full stop. He accordingly submits that he may be allowed to withdraw the appeal and present it in the manner prescribed. Para, Sri J. Payang, learned counsel for the respondent, does not object to the said proposal. Para, the appeal accordingly stands dismissed on withdrawal. Registry to return the certified copy to the party so as to enable for presenting the so as to enable the party to make the challenge in the manner prescribed.
Lordship.
I also dismiss, sir. In view of the order passed, I still dismiss.
Item 4.
Case is ready as regards for hearing.
Paper book ready.
Ready, paper book is there. We can have it for hearing whenever.
After Bihu.
Paper view, Lord. Solid.
So Bihu, my lord, some, I have some.
If paper book is there, let us hear it. Today is what? 24th.
Please, 24th.
We can have it on 3rd. 3rd April,
3rd April is difficult for me.
4th April,
8th,
4th April. Okay, 4th
maybe
April.
on 5th. I have to go to Delhi, Lordship, on 3rd of April.
You're a big man. You go
No,
to
no.
Delhi.
On 8th, it may be fixed.
Because immediately after Bihu, immediately after Bihu.
Okay, on 22nd then.
22nd.
Okay. Heard Sri K. Gupta, learned counsel for the appellant, as well as Sri S. K. Ghosh, learned counsel for the respondent.
In IA, I am tape.
No, we are not hearing. The paper book has been prepared. Prepared, no? Paper book?
Prepared.
Good month. Huh? Where you?
Not
Where
paper.
received the public?
You know, kindly see the last order. Not paper book with the statement, evidence of both the sides.
Okay.
Kindly see class. It's ready. Evidence of CW1, CW.
Para. As per office note dated 4/3/2025, the photocopies of the depositions and the exhibits have been made and placed on records. We have also been informed that copies of the same have also been furnished to the learned counsel for the contesting parties. Para. As agreed to by the learned counsel for the parties, list this appeal for hearing on 22nd of April 2025. Item 5.
May I please your 45, require a paper book, not yet prepared.
Records have come.
Think-
Huh?
Yes.
I say record. Today your name is not there?
There.
Oh, in the appeal. Heard 3 as the learned counsel for the applicant who submits that the records have been received. Full stop. Para. Also heard Miss B. Bhuya, learned APP Assam. Para. Let the paper book be prepared and the matter be listed for orders to fix a date of hearing.
Not okay. My pleasure. But the LCR has been received, so I'm not pressing for the interlocutory application right now. So maybe paper book maybe
Okay,
prepared,
same order, huh? BM Decker, huh?
maybe pick for early hearing, my lord, if possible.
Right, expeditious. Paper book be prepared expeditious. I'll go to the Lekhiba.
Much obliged, my lord.
Your Lordship. Lordship, as for office note, respondent has appeared, Your Lordship, and
You are the respondent.
as
Okay.
for office note dated 23.
No, he's already there.
Yes, sir.
Okay. Now, yes,
Lordship.
paper, records have come.
Records have
Records
come.
have-
How many depositions? How many witnesses?
Kindly. My lord, PW3 and DW.
3.
Three.
We can pass a similar orders instead of the paper book. They can have the
Yes, yes.
depositions.
Only because no exhibit.
No exhibit.
No ex-
We'll ask the registry to. This is your appeal, madam.
Yes, sir.
Have you given the depositions here?
No, yes, not that.
Where it is not there, Your
Okay, we will. Okay.
Lordship. F and Jaman, Your Lordship.
Heard Miss F. N. Jaman, learned counsel for the appellant, as well as S.K. Ghosh, learned counsel who has entered appearance for the sole respondent. Full stop. Para. Pursuant to the order of admission dated 12/2/2025, whereby records were also called for, comma, the TCR have been received. Full stop. Para. Office to prepare, office to make photocopies of the depositions which depositions, full stop. We have been informed that there are 3 numbers of PWs and 2 numbers of DWs.
3 number of
No, don't write it. Make the photocopies of the deposition
both the parties.
and depositions, and place the same on record and also furnish copies thereof to the learned counsel for the parties. List for orders immediately.
Lordship,
Thereafter.
status quo order is there, Your Lordship, that may be cut.
In matrimonial suit, my lord,
Lordship has passed order on 12/2/2025, Your Lordship.
The order of status quo.
my lord, the divorce was granted.
There's the status, the order of status quo only. Status quo on 12/2.
12.
The order of status quo passed on 12/2/2025 to continue till the next date of listing.
I'm deeply affected.
Madam Chaudhary, status quo vacated. Where are you? Your colleague said the status quo should be vacated, so you have vacated it.
I have seen like number
Okay, okay.
apply.
Under section 17, not required.
Just 2 minutes.
May I please?
Just 2 minutes.
My lord.
Madam will be appearing. How many PWs?
12, my lord.
Conviction under?
My lord, 302, 341 and 323. 302, my lord, life imprisonment and a fine of rupees 10,000. In default, my lord, simple imprisonment for 2 months. And my lord, 341, my lord, 15 days, simple imprisonment, my lord, fine of rupees 500.
It is okay. Yes, please.
And my lord, under section 323, my lord, 6 months, my lord, simple imprisonment, fine of rupees 1 crore. My lord, lordship will first find, my lord, the affair, my lord, which lordship will find at page number 5, exhibit 1, my lord.
What is the date?
Date is, my lord, 2nd, my lord.
Where do you get?
My lord, in the form, my lord, you will get.
Here there is no date. Where?
It's
Page 1, lordship will find in the page number 1.
Page 7. Okay, 29. Right. No. This is the receipt date.
Lordship will find at page number 1,
This is
my
not
lord.
Vasanto, this is Binoy. Maybe in the form they have recorded the date.
Yes, page number 1.
FIR they have not, Azahar they have not written the date.
Occurrence is at, my lord, on 1st of September 94 at about 9 p.m.
Was 1994.
2014, my lord.
2014.
Yes, 19/2014 at about 9 p.m. Then, my lord, FIR, my lord.
9 p.m.
Yes.
And Azahar second.
Aja lost on, my lord, 2nd of September 2014 at about 3 p.m. my
By PW1.
by PW1. He is an injured witness, my lord. First, my lord, case was registered under section 341, 325 and 326/34 of IPC. Then subsequently, my lord, on 15/9/14, my lord, the victim died on, my lord, 13/9/14. So on the prayer of the IO, my lord, section 302 was added on 15/9/2014. In the, my lord, affair, we will find the names of, my lord, 3 accused persons. In the form also at page number 2, lordship will find Tushar Nath, he is the, my lord, appellant. Then, my lord, Tilok Kumar Nath, he has been acquitted, my lord. He is the brother, my lord, of the accused number 1. And Profullo Kumar Nath is the, my lord, the father of the present appellant. He has been convicted under section 341 and 323 IPC. And he has been sentenced only to fine.
You are Tushar.
I am Tushar, my
Tushar, and who's the other who has been acquitted? Brother.
Tilok Kumar Nath is the brother, my lord. And Profullo Kumar Nath is the father of the accused appellant.
Fine.
Only fine, my lord.
Yes.
Then, my lordship will come to, my lord, page number 5. Where is the affair, my lord?
Please wait.
Page 5, exhibit 1, my lord.
Yes.
The Vasanto Kumar Nath has lost the, my lord, affair. Humble submission is that around 9 p.m. on 1/9/2014, when I, along with my co-villagers, Joleshwar Nath, he is my lord PW2. He also sustained some injury, simple injuries. Both PW1 and my lord PW2, they sustained simple injuries. Then my lord Robin Chandra Nath, my lord, he is PW3. And Sri Bankim Chandra Nath, he has not been examined. We're talking on the road situated in front of our house over the matter of walks. The below mentioned accused number 1, the present appellant, came riding a bicycle in high speed in a careless manner and hit us in a careless manner. As we scolded the accused person a bit, the accused person ran away to his home with his bicycle. And after some time, the accused, accompanied by other accused persons, came together in a gang with sharp weapons such as dao and axe and iron rod in hands, and suddenly intercepted us with the intention of killing and assaulted us randomly with iron rod. When my younger brother Uttam Kumar Nath, aged 30, and the above mentioned Jaleshwar Nath resisted them with the help of some neighbors, the accused person assaulted my younger brother randomly with the backside of the axe.
This is Uttam is the deceased.
Uttam is the deceased, my lord.
Okay.
The accused person assaulted my younger brother randomly with the backside of the axe. Here, my lord, allegation is that, my lord, all the accused persons, they have assaulted his younger brother randomly with the backside of the, my lord, axe, my lord, and thereby caused injury. They caused injury to various parts of Jaleshwar Nath by assaulting him with iron rod. We made a hue and cry and became able to save ourselves after snatching the axe, snatching an axe and an iron crowbar somehow from the possession of the accused persons. I sustained injuries on head, hand, and various parts of my body, and my younger brother Uttam Nath sustained injuries in abdomen and various parts of his body. We three took treatment at Bongaigaon Civil Hospital. Since doctor found the condition of my brother critical, he was shifted to North Bongaigaon Lower Assam Hospital. Now he is undergoing treatment in critical condition. I therefore pray to you to take necessary steps by investing into the matter and oblige. This is the my lord affair. FIR story, my lord, all the accused person is assaulted by my lord. Backside of the axe causing injuries to the my lord, the deceased.
Yes.
Then, my lord, I will come to the evidence, my lord, subsequently, my lord. Then, my lord, the name of the 3 accused persons has been given, my lord. And accordingly, case was registered under section 341, 325, 326, 34 IPC, my lord. And on completion of investigation, my lord, charge sheet have been submitted against all these 3 accused persons, my lord. Lordship will find the charge sheet at page number 102, exhibit 7, my lord. I'm sorry, yes, exhibit 7. So search sheet was submitted, my lord, against all the 3 accused persons under section 341, 326, 302/34 IPC. Then, my lord, this accused persons, my lord, against this charge has been framed, my lord, under 3 heads. Lordship will find at page 8.
There was an examination on Tushar on the juvenility.
That was, my lord, rejected.
Rejected.
So his age was found to be, my lord, around 21 years of age.
Okay. That plea was not accepted by
Yeah,
the court.
that
Okay.
was not accepted.
Okay.
So, my lord, charges with 3 heads, lordship will find at page 8, my lord. First, my lord, charges Prafullanath, Tiloknath, and Tusarnath as follows: that you on 1/9/2014 at about 9:30 p.m. at village so and so under so and so in furtherance of common intention wrongfully restrained Robin Nath, Basanta Kumar Nath, Jaleshwar Nath, and Bankim Chandra Nath, and thereby committed an offense punishable under section 341 /34 of the Indian Penal Code. Then, my lord, secondly, that you on the same day, time and place in furtherance of common intention, inflicted blow to Uttam Nath with axe due to which he succumbed to the injuries on 13/9/2014 at around 8:30 p.m. and thereby committed an offense punishable under section 302/34 IPC. And thirdly, my lord, on the same day, time and place in furtherance of common intention, voluntarily caused hurt to Basanta Kumar Nath and Jaleshwar Nath and thereby committed an offense punishable under section 323/34 IPC. So, my lord, these are the, my lord, offenses for which charge has been framed, my lord. Then during the trial, my lord, altogether, my lord, 12 witnesses were examined. From defense, my lord, no witnesses were examined. So coming to the, my lord, the witness of, my lord, PW1, he is Vasantanath informant and he sustained some injuries, my lord. So lordship will kindly come to his evidence at page 15.
Yes.
I know the accused persons around 8:30 p.m. to 9 p.m. on 1914. Jaleshwar Nath, PW2, Bankim Nath not examined, Robin Nath, PW3, and I was sitting on the PW road in front of our house and talked with each other. While we were sitting, accused Tushar Nath went past of us by riding a bicycle at high speed. Tushar Nath came inebriated. I asked Tushar Nath as why he came in such a high speed, and I said it could hurt us as we were sitting. Then Tushar Nath stopped riding the bicycle and quarreled with us. Jaleshwar Nath settled the matter and sent him thereafter. But around half an hour later, Tushar Nath and his father Prafulla Nath came there. I was sitting on one end of the row. Arriving there, Prafulla Nath found me first and he assaulted on my head with rod. So, my lord, Prafulla Nath assaulted, my lord, the PW1 on his head with a rod. Then I fell down. Jaleshwar Nath was sitting beside me. When Jaleshwar resisted, Prafulla Nath assaulted Jaleshwar with iron rod. When I felt a little bit good, I snatched the rod from Prafulla Nath with the help of Jaleshwar. Then my brother, Uttam Nath, he is the deceased, my lord, arrived there. Seeing the hue and cry, Uttam Nath asked what was going on. Then Tushar Nath, who was hiding under the shadowy part of a tree, came out and beat in Uttam's lower abdomen with the blunt side, that is the back side of the axe. This is the, my lord, imputation in the court, my lord. I will come to the, my lord, his cross-examination, my lord. This fact was not stated before the policeman. I will come to the cross-examination, then to the IO, my lord. So then Tushar Nath, who was hiding under the shadowy part of a tree, came out and beat in Uttam's lower abdomen with the blunt side, that is the back side of the axe. At that moment, Uttam Nath was on the bicycle. Then Uttam put down the bicycle and snatched the axe from Tushar. Thereafter, Uttam and 4 of us went home. Injured also, my lord, went along with the, my lord, these witnesses, my lord. Thereafter, accused Tilok Nath arrived at the place of occurrence, and when he asked what was going on, Jaleshwar told about the incident. After going home, since Uttam was suffering from severe stomach ache, we took him in the car of Somiran Kumar Nath and first informed about the incident at the PS. Police took us to the civil hospital. Doctor stitched the injuries of my head and got Uttam admitted in the hospital. Jaleshwar Nath also got treated. Around 4 p.m., as stomach pain increased, we took Uttam to Lower Assam Hospital. His operation was done at Lower Assam Hospital. Uttam's kidney got damaged, but from the, my lord, medical postmortem report, we will find, my lord, there is no such injury in the kidney. On 13/9/14, Uttam succumbed to his injuries while he was undergoing treatment. The next day of occurrence, that is on 2/9/14, I lost the Ajahar. Exhibit 1 is the Ajahar that I have lost. Exhibit 1:1 is my signature. The police seized the axe with flat bamboo handle, and an iron crowbar with which we were assaulted. These were, my lord, seized from the, my lord, this informant, my lord. Exhibit 2 is the seizure list. Exhibit 2 is my signature. Material exhibit 1 is the seize thou. Material exhibit 2 is the crowbar. The police examined me. Then, my lord, lordship will come to the cross-examination. The houses of Jamini Bormon and Joyanto Bormon are situated near the place of occurrence. About 15 to 20 people came to the place of occurrence. I do not remember the names of the people who came there. It was a dark night. The place of occurrence is the PWD road. People move and vehicles fly on the road. The house of the accused is situated at a distance of about 1 kilometer from the place of occurrence. There are houses of people in both sides of the road, that is the place of occurrence. It is not a fact that I did not state before the police that when we were sitting, accused Tushar got down from his bicycle and involved in altercation with us. The whole incident lasted from 8:30 p.m. to 10 p.m. It is not a fact that I did not state before the police that about half an hour later, Tushar and Prafulla came there, that I said that they came after few moments. It is not a fact that I did not state that Prafulla had assaulted Joleshwar and me with iron rod. Instead, I said that the accused person had assaulted us. It is not a fact that I did not state before the police that after feeling a little good, I snatched the iron rod from Prafulla with the help of Joleshwar. My lord, this is important, man. It is not a fact that I did not state before the police that at that time, Uttamnath reached there and then Tushar came out from behind the shadow of the tree where he was hiding and beat in the lower abdomen of the Uttamnath with the blunt side of the axe. It is not a fact that I did not state before the police that Uttam snatched the axe from Tushar and thereafter all of us went home.
Where is the contradiction? He has denied the contradiction.
Yes, my lord. But this fact he did not state before the, my lord, IO, which I will come to the evidence of IO, my. This fact were not stated before the IO, my lord. First time in the court, my lord, he has stated. That contradiction is there, my lord. I will come to, my lord,
Denied the contradiction. That means he stated. But I think that the IO statement is not clear. We'll see the 161. Madam, check the records also.
The rates recorded is double negative.
We'll check the record 161. That is clear everything.
this contradiction was put to the, my lord, witness, which he has denied, my. That has been proved, my lord, from the cross-examination of the, my lord, investigating officer.
We'll see the 161.
Yes, my lord, definitely. If it is there, my lord, 161, I have nothing to, my lord, submit on that point, my lord. Then, my lord, it is not a fact that I did not state before the police that later Tiloknath came and asked about the incident and Uttam was suffering from stomachache. The incident took place on the road in front of our house. Around 10 p.m., we reached the civil hospital. Bonkim, Joleshwar, Uttam, the driver and I came to the hospital. We got treated on that night itself. I was not admitted in the hospital. Doctor did not advise me for better treatment, but Uttamnath was advised to do so. After I got assaulted in my head, blood was oozing from there. Next day at noon, I lost the Ejahar. About 3 days later, police went to the place of occurrence. Police took my signature in Exhibit 1, that is the seizure list at my home. When I put my signature, the seizure list was written. It was not a fact that
Exhibit
material
1, perhaps it will not be Exhibit 1. Exhibit 1 is the FIR, Ejahar.
Yes, my
Seizure
lord,
list cannot
exhibit,
be exhibit.
this is my lord, Exhibit 2, I
I
think.
think it should be 2.
Exhibit 2. It is not a fact that material exhibit 1 and material exhibit 2 were not used in the incident. It is not a fact that Joleshwar and I hunted deer in the village by using axe and crowbar and we sell deer in the daily market. And since the accused person prevented us from doing this, we lost the false case against them. I do not know who had written Exhibit 1. it is not a fact that on the day of occurrence, the accused person did not assault Joleshwar, Uttam and me, and we did not sustain any injury. Joleshwar Nath is my distant cousin. This is the, my lord, evidence of PW1.
Doctor, may I read?
Just, please do.
That part is not there. He was hiding behind the tree. That
Shadow it,
is-
no, the main
Yes,
part.
entire I'll read all of it. Statement of Bosanta Kumar Nath. মই এই মোকৰ্দমাৰ গুচৰীয়া হয় সোধাত তেওঁ কয় যে মোৰ নামো ঠিকনা ওপৰত লিখা মতেই সত্য হয় মোৰ বয়স 30 বছৰ মই এনে থাকো যোৱা 1/9/2014 ইংৰাজী তাৰিখে ৰাতি অনুমান 9টামান বজাত আগৰ পৰৰ সন্মুখৰ ৰাস্তাৰ ওপৰত মই আৰু আমাৰ ঘৰৰ সন্মুখৰ ৰাস্তাৰ ওপৰত মই আৰু আমাৰ একে গাঁৱতে থকা জলেশ্বৰ নাথৰ বয়স 30 বছৰ আৰু শ্ৰী ৰবেন চন্দ্ৰ নাথ আৰু শ্ৰী বংকিম চন্দ্ৰ নাথ আমি চাৰিজনে কাম কাজৰ বিষয় লৈ কথা পাতি থকা অৱস্থাত আমাৰ গাঁৱৰ প্ৰফুল্ল কুমাৰ নাথৰ পুত্ৰ শ্ৰী তুষাৰ নাথে মদ পানী খাই চাইকেলত উঠি তীব্ৰ গতিত চলাই আহি মোক খুন্দা মাৰে ফলত মোৰ শৰীৰত জখম পাওঁ আমি তুষাৰ নাথৰ দুই এক কথা কৈ গালি দিয়াত তুষাৰ নাথে চাইকেলখন লৈ ঘৰলৈ পলাই যায় তাৰ কিছু সময় পাছত উক্ত ঘটনা কেন্দ্ৰ কৰি তুষাৰ নাথে লগতে তাৰ পিতা প্ৰফুল্ল কুমাৰ নাথে আৰু ভাই শ্ৰী তিলক কুমাৰ নাথে লগত লৈ দলবদ্ধভাৱে হাতত কুঠাৰ দা আৰু লোহাৰ ৰড লৈ আমাৰ ওচৰত ওলাই আৰু আমাক প্ৰাণনাশৰ উদ্দেশ্যে আগচি ধৰি লোৰ ৰডেৰে মাৰধৰ কৰে মোৰ ভাই উত্তম দাস আৰু তাৰ চুবুৰীয়া শ্ৰী জলেশ্বৰ নাথে বাধা দিয়াত পদকীয়াজনে মোৰ সৰু ভাই উত্তম নাথক কুঠাৰৰ ওলোটা পিঠি দি কোবাই জখম কৰি ঘটনাৰ পাছত পদকীয়া জনৰ হাতৰ পৰা কুঠাৰ এখন আৰু লোৰ চাবুল এডাল কাঢ়ি ৰখাত ৰক্ষা পৰো মোৰ মূৰত জখম হয় লগত হাতত থকা দেহত জখম হয় হাতত তথা দেহত জখম হয় লগে লগে আমাক তিনিওজনকে বঙাইগাঁও চিভিল হস্পিটেললৈ
Okay, it's there.
my lord that
Substantially it's there.
no, only that part is not there my lord
Substantially it's there.
it's there my lord. TW1 নহয় মেইন তুষাৰ নাথে মোৰ সৰু ভাই উত্তম নাথক কুঠাৰ আৰু দুটা পিঠি কোবাই জখম কৰে মোৰ ভাই উত্তম নাথ আৰু তাৰ পুতে জলেশ্বৰ নাথে বাধা দিয়াত পদকীয়া গণে মোৰ সৰু ভাই উত্তম নাথক কুঠাৰৰ দুটা পিঠি
My lord, in this 161, my lord, Lordship has heard it, my lord, that all the accused person is assault, not Tushar Nath. But in the, my lord, in the evidence in the court, my lord, it is stated that, my lord, Tushar Nath, he was hiding in a, my lord, shadowy part, and then he come and he assaulted on, my lord, the
This is
lower abdomen by a blunt side of the head. That is the contradiction I am on, my lord. Because implication in the 161, my lord, all the accused person, my lord. Then, my lord, then I am coming to, my lord, evidence of PW2, my lord. He is Joleshwar Nath, my lord. He also sustained some injuries. The occurrence took place, may I read it, my lord?
yes, yes.
The occurrence took place on 1914. I know the accused person. Around 8:30 p.m. on the day of occurrence, Basanto, Bonkim, Robinnath, and I were sitting near the road and talked with each other. We were talking on the road in front of Basanto's house. At that time, accused Tushar Nath rode his bicycle at high speed, almost touching us, but did not make any contact. At that time, when Basanto asked him as why he had ridden the bicycle at such a high speed, Tushar got down from the bicycle and involved in altercation with us. When I convinced Tushar not to engage in quarrel, he went home. We four were still there at that moment. Few moments later, Tushar Nath and his father, Profulla Kumar Nath, also came there, and Profulla Nath asked, using abusive language, who had prevented his son. Bonkim and I called Prafullo Nath as uncle and Ata, grandfather respectively. Bonkim and I said that we do not know. Then Tusar pointed towards Basanto Nath. Prafullo Nath was holding a rod in his backside. I did not know about it. As soon as Tusar pointed towards Basanto Nath, Prafullo Nath moved the rod across my head and randomly assaulted him, Basanto. Then I resisted him. When I resisted him by raising my both hands, he assaulted on my right shoulder with the rod. At that time, I became angry and I fell Prafullo Nath down. He fell down in a ditch near the road. Prafullo Nath is the father. Then Basanto Nath and I snatched the rod from Prafullo Nath. When we were scuffling to take hold of the rod, Uttam Nath came from the northern side, and reaching there, he thought that we were quarreling. He got down one of his legs from the bicycle and asked that what was going on. At that moment, Tusanath, who was there holding an axe, assaulted in the lower abdomen of Uttam with it. Uttam Nath was a healthy person. Even after being assaulted, Uttam Nath snatched the axe from Tusar. At that time, Tusar ran away and called his elder brother Tilok Nath. Tilok Nath asked angrily what had happened. I told about the incident. When Prafullo Nath had fled away running from the place of occurrence, he did not find a way and he entered the courtyard of Basanto Nath. I asked Tilok to take his father away. After the occurrence, Uttam Nath became unstable due to his stomach pain, and we took him to the civil hospital in a car, which were near our house. Basanto, Uttam and I took treatment at civil hospital. As Uttam Nath could not tolerate the pain, around 3 a.m., we admitted him at Lower Assam Hospital. Next day, the doctor performed the operation of Uttam. After keeping him in ICU for 13 days, on 13/9/14, Uttam succumbed to his injuries. Basanto Nath lost the Azahar in connection with the occurrence. Police came to the place of occurrence and seized the axe and rod, which were used in the incident. I put signature in the seizure list. Exhibit 2 is the seizure list. 2 is my signature. Material exhibit is the seized iron axe. Material exhibit 1 is the iron crowbar. Then Lordship will kindly come to my lord the cross examination of. Prafullo Nath lost the case in police station against Basanto and me, alleging that we had assaulted them and he had taken away 60,000 rupees. So, my lord, there was a cross case, my lord. But unfortunately, my lord, it was not pointed out, my lord. That is why, my lord, that trial was not, my lord, held together before the sessions court, my lord. If there is a case and cross case, my lord, the usual practice is that, my lord, the both should be heard by the same judge, my lord. Maybe, my lord, because it was not pointed out, and that is why, my lord, trial was held in the court of my magistrate. And, my lord, I have got a copy of that judgment, my lord. They got acquittal. This Basanto Nath and, my lord, Jaleshwar Nath, they were acquitted in the, my lord, GR case, my lord. It is not a fact that a case has been pending over the matter that on 2015, Basanto and I had killed Mintu Nath. That is a, my lord, separate issue, my lord. The place of occurrence is situated about less than half kilometer away from my house. The house of Robin Nath is situated near my house. The house of Bonkim Nath is also situated about less than half kilometer away from the place of occurrence. It was a moonlit night on the day of occurrence. Some people came near the place of the occurrence. They witnessed it from a distance. Since I was involved in the incident, I cannot say who came there. The house of Jayanto Bormon, Jamini Borman, other people are situated near the place of occurrence. One can reach the house of Prafullo Nath after crossing my house. His house is also situated about less than half a kilometer away from the place of occurrence. The place of occurrence was the PWD road. There are houses of families stretching from the place of occurrence to the house of the accused, and people and vehicles pass by on that road. It is not a fact. This is again important, my lord. It is not a fact that I did not state before the police that when Uttam Nath was on the bicycle, Tushar Nath assaulted him with an axe, my lord. This also, my lord, he did not state before the IO, my lord.
But he has not, contradiction he has denied.
Yes, my lord, but we have to put to the witness, my lord. If something has been stated in the, my lord, in the evidence for the first time, my lord,
Yes.
we have to put it to the witness first, my lord.
No, if he accedes to the suggestion
My lord.
that you have not stated this before the police.
Yeah.
If he has actually not stated, he said, yes, I have not stated.
Yeah.
We have found many cross-examinations.
Yeah.
But here he has not accepted the contradiction. He
Yeah.
said, yes, I have stated before the police.
For that reason, my lord, we have put to the, my lord, the investigating agent to confront it, my lord, whether he has actually stated before the IO or not. That is 145 of the Evidence Act.
No, that you have done, but 161 is before us. We can recheck.
Yes, yes, definitely, my
It's
lord.
only, these are all parts of records.
Yes,
He may omit something. The IO may omit something, but records will not.
yes, yes, definitely, my lord. Lordship can look into this, my lord, 161 statement, my lord. But as from this evidence, my lord, what I am, my lord, submitting before your lordship, my lord, that assaulting by the, my lord, Tushar, those were not stated before the IO, my lord. It was stated for the first time in the court, my lord, and this has been proved, my lord, by my lord, cross-examining the investigating officer. That he has not stated before the, my lord, IO.
We will see, look into that.
Yes, my lord. Tushar not assaulted him with the axe. It is not a fact that I did not state before the police that when Uttam Nath was on the bicycle, Tushar not assaulted him with the axe. It is not a fact that I did not state before the police that Uttam Nath was coming on a bicycle from the northern direction. It is not a fact that I did not state before the police that when I resisted Prafulla Nath by raising my both hands, he hit me too on my right shoulder with the iron rod. Then I became angry and fell Prafulla Nath down. It is not a fact that I did not state before the police that Uttam Nath snatched the axe from Tushar. All these facts were not stated before the IO. It is not a fact that I did not state before the police that Tushar ran away and called Tilak Nath and Prafulla Nath. Tushar ran away and called Tilak Nath, and Prafulla Nath also ran away and entered in the courtyard of Basanta Nath. We three took treatment in the civil hospital on that night of the occurrence itself. Deer are not seen in our area. It is not a fact that deer are seen in our area. And Basanto and I hunted deer by using axe and crowbar and sell it in the daily market. And that as the accused person resisted us in our activity, we have lost a false case against them. It is not a fact that on the day of occurrence, the accused person did not assault Basanto Nath and Uttam Nath. It is not a fact that we in fact assaulted the accused persons, and in order to defend ourselves, we brought iron rod and axe from our house and handed it over to the police. My lord, these are the most two important witnesses of the case, my lord.
First, may I clarify that point that the contradiction, I think
Yes.
the contradiction. 161 of Dolesor, she Tushar Nathe hatot ona kuthar khonere Uttam Kumar Nathok akraman kore. Or Uttam Kumar na rastat, that part there, but riding bicycle may be optional.
Then, my lord, these are the, my lord, two injured witnesses. Other, my lord, though Robin Chandra Nath was told that he was also sitting there, my lord, but in his evidence, my lord, we find him to be a hearsay witness, my lord. May I just read, my lord, Robin Chandra Nath, my lord, he is PW3 at page 24. I know the informant Basanto Nath. I know accused Prafulla Nath, Tushar Nath and Tilak Nath. The occurrence took place about 3 years ago. Around 9 p.m. on the day of occurrence, I was returning home after closing my tea stall at Baskari Chowk. While coming, I saw Joleshwar Nath, Bankim Nath and Basanto Nath sitting on the road in front of the house of Basanto Nath. They were eating things like muri puff rice, kira flattened rice, and they were getting ready to go for fishing. When I asked them where they were going, they replied that they were getting ready to go for fishing. I also got down from the bicycle and also ate slice and muri along with them. At that moment, Tushar and Prafulla came from the backside and assaulted Basanto. Thereafter, Prafulla assaulted Jaleshwar Nath on his head with a rod. I resisted, but he did not stop. As the commotion arose, I went home by riding the bicycle. Here, my lord, he becomes hearsay witness, my lord. Later, I came to know. Though, my lord, he was very much present with my lord PW1 and PW2, my lord. But in his evidence, he has stated, later I came to know that after I had returned, Tushar Nath assaulted Uttam Nath with an axe. And then he was taken to the hospital, but later Uttam Nath succumbed to his injuries. I visited the hospital to know about the health of condition of Uttam. Uttam Nath got treated at so-and-so. Material exhibit 1 is the axe, 2 is the crowbar, scissor list. Then, my lord, Then, my lord, his cross-examination. My tea stall is situated at a distance of half kilometer from the place of occurrence, and my house is situated about another half kilometer away from the place of occurrence. One has to cross the place of occurrence to reach my house from the tea stall. I met Jaleshwar, Bonkim, and Roshantonath at the place of occurrence. It is not a fact that I did not sit before the police that they were eating some things like muri chira. When I asked them where they were going, they replied that they were getting ready for fishing. I also get down from the bicycle, slice muri. These are not that important, my lord. So we can skip this, my lord, not that important, my lord. He has stated that my lord Tushar Nath and Prafulla Nath assaulted my lord PW1. In the cross-examination, my lord, at that time coming from the back, Tushar Nath and Prafulla Nath assaulted Basanto Nath. Thereafter, Prafulla Nath assaulted Jaleshwar Nath on his head with a rod. I resisted him. So he was very much present at the place of occurrence. Then the house of Jayanto Burman, Jamini Burman was situated near the house of Basanto Nath. On the day of occurrence, it was a dark night and it was summer season. Basanto Nath and Jaleshwar do not have dispute with the accused person. In connection with the incident of assault, my signature was obtained in exhibit 2. It is not a fact that Tushar Nath and Prafulla Nath did not assault Jaleshwar and Basanto Nath. After 5 days of occurrence, I visited the hospital to know about the health condition of Uttam Nath. Uttam is the younger brother of Basanto. Uttam and Basanto reside in the same house. I do not remember who told me that Tushar Nath had assaulted Uttam. The house of accused person is situated about 1 kilometer away from the place of occurrence. The incident took place on the PW road. People move and vehicles fly on the road. It is not a fact that I was not present at the place of occurrence and that I was in my shop. It is not a fact that Tushar Nath did not assault Uttam Nath. It is not a fact that Uttam Nath did not die as a result of this incident. Then, PW4, he is Jayanto Burman. He is also a hearsay. The house of informant Basanto Nath is situated near my house. I know all the 3 accused persons. The occurrence took place on 1/9/14. On the day of occurrence, I was not at home. I went to attend Annaprasan of so-and-so. When I returned home in the night, I came to know from my family members that an incident of assault took place in the village. Next day in the morning, asking the neighbor, I came to know that assault took place between Basanto Nath, Uttam Nath, Jaleshwar Nath, Tushar Nath, Prafulla Nath, and Tilak Nath. I heard that Basanto Nath, Jaleshwar Nath, and Rabindranath were sitting on the road around 9 p.m. Since Tushar Nath was returning from his shop, an altercation took place between them. Later, both the parties left the place, but after some time, Tushar Nath and his father Prafulla Nath came and again started quarreling. And that moment, when Uttam Nath came from somewhere and resisted them, a serious quarrel took place between them. Basanto Nath, Jaleshwar Nath, and Uttam Nath got injured in the occurrence, and they were taken to the civil hospital. Although Basanto and Jaleshwar Nath were released from there, Uttam was admitted. But on 13/9/14, Uttam succumbed to his injury. Then, my lord, cross-examination, he stated that he did not see the occurrence. I do not remember exactly from whom I came to know about the occurrence. When an incident takes place, generally everyone comes to know about it. Prior to this occurrence, I have not heard and see any quarrel between both the parties. It is not a fact that as I have stated today, I did not hear about the occurrence from anyone. And I have reduced falsely today and I have heard it. Then my lord, PW5, he is also my lord hearsay witness. Nomani Bormon alias Nolani Bormon. I know informant Basanto Kumar Nath and the three accused persons. During the occurrence, I was in Lower Assam hospital due to the ill health of my daughter. The occurrence took place about 4-5 years ago. I heard from people that assault took place between Uttam alias Chotu, the younger brother of Soneshwar Nath, and accused Prafulla Nath, Tushar Nath, and Tilak Chandra Nath. Another name of Tilak is so and so. Later I heard that Chotu passed away at Lower Assam hospital. Chotu's house is situated. And my lord, cross-examination, there is nothing, my lord. Because he is just a hearsay witness, my lord. He has heard in the hospital, my lord, about this incident, my lord. Then, my lord, Torongo Nath, my lord, who has arrived at the place of occurrence after the occurrence, my lord. I know informant Basanto Kumar Nath and I know the accused persons. Around 9:30 p.m., that is the occurrence, the occurrence took place. At night on the day of occurrence, hearing a hue and cry at Basanto Nath house, I arrived there and found Uttam Nath in seriously injured condition and he was unable to speak. I also saw Joleshwar Nath and Basanto Nath in injured condition. When I asked them what had happened, they said that when Basanto Nath, Joleshwar Nath, Rabindranath and Bankar Nath were sitting on the PW road in front of the house of Basanto Nath, Tushar Nath came from somewhere and made physical contact with Basanto Nath by his bicycle. Then altercation took place between them. Later, Tushar Nath went to his house and returned to his father, taking a crowbar with them. At that time, when Uttam Nath reached there riding a bicycle, Tushar Nath assaulted Uttam Nath with the axe. It was heard that Tushar Nath's father, Prafulla Nath, assaulted Basanto and Joleshwar with crowbar. Thereafter, leaving the crowbar and the axe there, Tushar and his father left the place. I asked the injured person to go to the hospital and returned home. They took treatment at Bongaigaon Civil Hospital. From there, Uttam Nath was admitted at Lower Assam Hospital. On 13/9/14, Uttam Nath succumbed to his injuries in the hospital. On the night of occurrence, when I went to Basanto Nath houses, I met Tilak Nath there who was looking for his father. But as I did not find his father Prafulla Nath there, I asked Tilak to return home. When I went there, Uttam Nath was sitting, placing his hand on his stomach. Then my lord
I did
prosecuted.
not witness the incident.
He is also, my lord, not an eyewitness. I did not witness the incident, my lord. Then, my lord, Basanto Nath told me about the occurrence. It is not a fact that I did not state before the police that Basanto Nath told me that Tushar Nath assaulted Uttam Nath with an axe and Tushar's father, Prafulla Nath, assaulted Basanto and Joleshwar Nath with crowbar. This fact, my lord, he has denied, my lord. Stating that Basanto has told him about, my lord, assault of Uttam Nath by Tushar Nath, and my lord, this Basanto and Joleshwar by the other
How many
two,
injuries were sustained?
by the, my lord, deceased.
Deceased?
Single,
Single. On the abdomen.
on the. Then, my lord, next is also, my lord, Onu Bormon also, my lord, hearsay, my lord. I do not find anything in our evidence, my lord. May I read it or skip it, my lord?
Just cursory.
My lord, I know informant Basanto Kumar Nath. I know the accused person also. Around 9 p.m. on 1/9/14, the occurrence took place. On the day of occurrence, when I was cooking at home, I heard a hue and cry. Later, I went to Basanto Nath house and came to know that from his mother, that Prafulla Nath and Tushar Nath had assaulted Uttam Nath. I came to know that the injured person, Uttam Kumar Nath, Basanto Nath, Joleshwar Nath, were taken to the hospital. At first, they were taken to Bongaigaon Civil Hospital as Uttam Kumar Nath sustained severe injury. He was taken to Lower Assam Hospital. On 13/9/14, Uttam succumbed to his injuries. Then, my lord, cross. it is not a fact that I did not state before the police. Later I went to the house of Basantonath and I came to know from the mother of Basantonath that Prafullonath and Dusanath assaulted Uttamnath. So this fact also, my lord, he did not state, my lord, before police, that he came to know from the mother of my lord Basantonath. Then my lord PW8, my lord Laljit Nath, he is a my lord witness to the inquest, my lord. Magistrate had done the inquest, my lord, at the hospital, my lord, because he was in the hospital for, my lord, about 13 days, my lord. After his death, my lord, his inquest was done in the hospital. Then, my lord, next witness is my lord PW9, who is a doctor, my lord, who is a medical practitioner in the Lower Assam Hospital, my lord, Bongaigaon. On 13/9/14, I was working as medical practitioner in ICU at Lower Assam Hospital. The patient Uttam Kumar Nath, 30 years, was admitted in the hospital on 2/9/2014 at 5 a.m. The patient was operated in our hospital and the patient was shifted to ICU. This is important, my lord. The patient developed septicemia and the patient died on 13/9/2014 at 8:30 p.m. in the hospital, my lord. Because after 15 days of the occurrence, my lord, he was undergoing treatment from 2nd, my lord, till 13, and he expired on 13, my lord. And while he was in the hospital, my lord, he developed, my lord, septicemia. Then I will come to, my lord, post-mortem report also. Then, my lord,
Yes.
the next witness is my lord PW10, my lord. She is, my lord, Dr. Meenakshi Kalita, my lord. He is the, my lord, doctor who performed the, my lord, post-mortem examination, my lord. On 15/9/14, I was working as senior medical and health officer at Bongaigaon Civil Hospital. On that day at about 10 a.m., I conducted a post-mortem examination on the dead body of Uttam Kumar Nath. 30 years, well, Hindu one being identified by so and so, so and so. There, my lord, external appearance, a healthy male of average build, medium complexion in fresh condition, a longitudinal scar present with stitch over abdomen, laparotomy on 10 centimeter long about, a small 2 centimeter and 1 centimeter scar present on right side of abdomen, which was used for, my lord, for drainage, my lord. So one injury, my lord, that longitudinal scar was there, and another injury was there for, my lord, for the draining of, my lord, those blood and all, my. Then, my lord, coming to the abdomen, my lord. A longitudinal scar present with multiple stitch over abdomen, laparotomy found. A small 2 centimeter, 1 centimeter scar present on the right side of abdomen. Peritoneum congested, cavity filled with blood-stained discharge. Mouth, pharynx and osteophagus intact and filled with blood-stained fluid. Stomach and its contents intact and congested. Then, my lord, this is the injury number 5, my lord. Small intestine and its contents, multiple gut injury with repairing stitch and slough and pus present over the small intestine. Then, my lord, large intestine and its contents, my lord, it is found to be intact, my lord, with mucosal, slough and facial manner. Then, my lord, other, my lord, parts of the body, my lord, which is mentioned, cranium and spinal canal, skull, vertebra, intact and healthy, membrane pale and osteomatous and intact, brain and spinal cord intact and healthy, liver, spleen, kidney, and bladder intact and congested. Organs of generation, external and internal, intact and healthy. Then, my lord, this thorax and also, my lord, these are all found to be healthy, my lord. And muscle, bones, and joints, injury absent, disease or deformity absent, fracture absent, dislocation absent. Then, my lord, the opinion given by the, my lord, the PM doctor. In my opinion, the cause of death is due to cardiorespiratory failure. Due to, my lord, the septic shock due to multiple gut intestinal injury. My. So finally, my lord, due to, my lord, cardiorespiratory failure, my lord, he died because of the, my lord, this septicemia occurring in the multiple gut injury intestine. It is antemortem in nature. Exhibit 5 is the post-mortem examination report. Scar means healing wound. In injury over abdomen, I have not mentioned the depth of the injury because it is a laparotomy wound, that is opening wound over abdomen. Then, my lord, next witness is, my lord, PW11 at page, my lord, 42. He is the investigating officer of the case, my lord. He is Joy Chandra Das. May I read it, my lord?
Just a minute. Yes, please.
On 2914, I was posted as second officer at Bongaigaon PS. On that day, OC.
Yes.
On 2914, I was posted as the second officer at Bongaigaon PS. On that day, OC received an FIR from Basanta Kumar Nath, which was registered as Bongaigaon PS case number so and so, and endorsed the case to me for investigation. Exhibit 1 is the said FIR, signature of so and so. On 3914, I visited the place of occurrence, that is a road at Basbury in front of the house of the informant. I inquired the informant and recorded his statement and that of other witnesses. I prepared sketch maps of the place of occurrence. The exhibit 6 is the sketch map. 6.1 is the signature. I seized the axe and one iron rod on being produced by the informant as a weapon of offense in presence of witnesses. Exhibit 2 is the said scissor list. 2.4 is my signature. Material exhibit 1 is the seized axe with bamboo handle, and material exhibit 2 is the said iron rod, which was flat on one side. On 6 and 14 at around 2:30, I went to Lower Assam Hospital to see the injured Uttam Kumar Nath. The injured was not in a position to talk, for which I gave requisition to the in charge doctor, Dr. Lower Assam Hospital, for recording the dying declaration of the injured. The carbon copy of the said requisition is in the case diary. On that day, I went to the house of the accused person but did not find them. I went several times in search of the accused persons but did not find them. On 13/9/14, I got the information from the hospital that the injured Uttam Kumar Nath has expired. It was night by that time, for which I did not go to the hospital. Next day, I went to the hospital along with the executive magistrate, Pallav Jyoti Nath. The inquest on the dead body of Uttam Kumar Nath was done by executive magistrate Pallav Nath in my presence and witnesses. Exhibit 3 is the inquest report. 3 is my signature of executive magistrate, which I know. Hereafter, the postmortem, the dead body of Uttam Kumar Nath was conducted at Bongaigaon Civil Hospital. On 14/9/2014, I made prayer before the learned CGM Bongaigaon for reading 302 IPC, which was allowed. On 13/9/14, accused Prafulla Nath appeared at a police station along with the order of Honorable High Court in respect of grant of anticipatory bail. After inquiry, I allowed Prafulla Nath go to bail. On my transfer, I handed over the case diary to the OC Bongaigaon PS. As revealed from the case diary, next IO was Sahajur Rahman. We worked together at the same PS. I acquainted with his writings and signature. Accused Tilok Nath also obtained anticipatory bail and appeared and appeared before SI Shahajur. The medical report of the injured and the postmortem report were collected by Shahajur Rahman, and on completion of investigation, submitted a charge sheet against the accused Prafullo Kumar Nath, Tilak Kumar Nath, Tushar Nath for offense under section 341, 326, 302, 34. Accused Tushar Nath was shown absconder in the charge sheet. Exhibit 7 is the said charge sheet. Exhibit 7 is the signature of SI Shahajur Rahman, which I know. Then my lord, cross-examination. I visited the place of occurrence on 3/9/2014. I went thereafter also in search of the accused person. The distance from Bongaigaon PS to the PO is about 25 kilometers. We received the FIR on 2/9/2014 at 3 p.m. The incident is of 1/9/2014 at about 9 p.m. There is no cause shown for delay in the affair. I recorded a statement of Tarangonath, Lolit Nath, Basantonath, and Dr. Rajesh Shaha on 9/14 at Lower Assam Hospital. Basanta Kumar Nath produced the seized weapon from his house. I have not seen these weapons. I have not sent these weapons to FSL for forensic examination. In Exhibit 6 sketch map, I have only shown the house of Nomani Bormon and Joyanto Bormon. Then, my lord, to prove the contradiction, my lord, this IO was, my lord, those contradictions were put to the IO, my lord. PW1 Basanta Kumar Nath did not state before me that accused Tushar Nath got down from the bicycle and entered into altercation. He stated before me that after some time, Prafullo Nath and Tushar Nath, but not that after half an hour. He did not state before me that Prafullo Nath attacked Puleshwar with iron rod. He did not state before me that Tushar Nath came out from darkness and attacked with the backside of the axe, which I am on, my lord. That when his memory was expressed, my lord, before the police, my lord, giving the informant, he did not say this important fact before the, my lord, IO. He stated before me that the accused person attacked his brother with iron rod and axe, but specifically did not state that Tushar Nath attacked with axe. He did not specifically state that Uttam Nath snatched the axe from the hands of Tushar Nath. Then, my lord, PW2, my lord. PW2 Joleshwar Nath did not specifically state, PW2 Joleshwar Nath did not specifically state that while Tushar Nath was on his bicycle, the accused Tushar Nath attacked him with axe. This is also, my lord, I am on this matter. He did not state before me that when he raised his both hands and prevented them, the accused Prafullo Nath attacked him with rod on his right shoulder, and out of anger, he threw Prafullo Nath on the ground. He did not state before me that Uttam Nath snatched the axe from the hand of Tushar Nath. He did not state before me that Tushar ran and called Tilak Nath, and Prafullo Nath ran inside the house of Basanta Nath. These are the, my lord, two eyewitnesses, my lord.
1 and 2.
1 and 2. Then, my lord, PW3, my lord, though he was present there, my lord, from his evidence we find, my lord, that he did not, my
He
lord.
said that he had gone away.
Yes, my lord.
He came later on.
Later on he came and he came to know, my lord.
Robin.
Yes, Robin Nath. Robin Nath did not state before me that Joleshwar, Bonkim and Basanta Nath were having Muri Chira, and they asked me also to have, at which he got down from his cycle, and asked him also to have, at which he got down from his cycle and had sliced bread and muri at that time. And muri, and at that time, Tushar Nath and Prafullo Nath came from behind and attacked Basanta Nath, and thereafter Prafullo Nath attacked Joleshwar Nath on the head with rod. Then, my lord, PW6, my lord, Tarangonath stated before me that he heard about the incident from the discussion of Basanta Nath, Joleshwar Nath, Robin Nath, and Bonkim Nath, and not that Basanta Nath narrated him about the incident. I do not know if any cross case was filed by accused Prafullo Kumar Nath against Basanta Nath and others. Then, my lord, PW 12, my lord, she is the doctor, my lord, of the Bongaigaon Civil Hospital, my lord, who had examined my lord Joleshwar and Basantata regarding my lord about their injuries, my lord.
May not be relevant so far as the implication against your client is
Yes, to
concerned.
Sana, there is
because
no, my lord,
The
implication.
others are not before us.
Yes, yes. But but what we find from the evidence of my lord doctor, that he gave opinion as the injury is simple in nature and caused by blunt object.
No, regarding whom?
My lord, this Basanto Kumar Nath. Though there is no implication against my lord Tushar, my lord, even my lord, the person, this father, my lord Prafullo Nath, he made assault on my lord Basanto Nath. But the injury, my lord,
Has this witness said anything about Uttam?
Uttam, he doesn't speak.
Then may not be
No,
relevant.
not
We are
necessary.
on the conviction of your client on the accusation against Uttam.
But my client is also, my lord, convicted under section, my lord, all these three sections. 302, 341 and 323.
If this goes and 302 remains, what will happen? Nothing.
Then life imprisonment, my lord.
It's better to argue on 302.
Yes, because already he is, my lord, more than 5 years and 3-4 months he is in jail, my lord. Then, my lord, their statement under section 313 square, my lord, recorded. Lordship will find those statement from page number 47, my lord. Two such statement, Lordship will find at page number 53, my lord.
Anything there?
Lordship, case number 1, question number 1, 2, my lord, denial. Then question number 3, my lord, he has given his reply. That we have not attacked anyone, rather we were attacked by them and rupees 60,000 was snatched from us. For which that, my lord, that trial of cross case was there, my lord. 58, yes. Him. Then, my lord, do you have anything to say, my lord? That is the last question, my lord. During that time, I was having a fertilizer shop at Nitya Bazar in Basbari. On that day, I, along with my father, was returning from my shop at around 9 p.m. My father was at some distance behind me. On reaching in front of the house of Basanto Nath, I was assaulted with fist blows by Basanto Nath, Joleshwar Nath, and 3 and 4 others. They took away rupees 16,000 from my pocket. On hearing my scream, my father also reached there. They also attacked my father. I managed to escape from there and went to my brother Tilok's shop. Tilok and I came back there and saw my father was confined inside the house of Basanto. Village people gathered there, and on their intervention, my father was released. My father sustained injuries and we brought him to Bongaigaon Civil Hospital. My father was admitted for 1 night there. I did not attack Uttam with act. We are innocent and falsely implicated. We filed a case against them. We gave evidence in that case. I do not know what happened to that case.
Your father's injury, any proof regarding father's injury?
In this case, it is not proved, but in the cross case, it was proved.
No, in this case.
In this case, it was.
No defense witness.
No, it was not proved, my. That is why, my lord, in the very beginning, my lord, submitted that it is my lord, the usual practice when there is a case and cross case, my lord.
But that has already been gone.
Yes, that is gone, my lord. That we cannot.
Now, what are your submission? How do you formulate?
Yes. So, my lord, my first submission is before the my lord, before this honorable court, my lord. If we go to the Azahar, my lord, this Azahar has been very promptly lost, my lord. Second day, though there is a delay of few hours, but it was promptly lost, my lord. And in the my lord affair, it was lost by the my lord, the brother of the my lord, deceased, my lord, who is also an injured witness who was present at the place of occurrence,
Yes.
my lord.
Yes.
And his affair, my lord, he has stated, I am coming to my lord only on Uttam's, my lord.
Yes, yes,
Assault on Uttam, my lord.
yes.
In his, my lord, affair, he has stated, my lord, the accused person assaulted my younger brother randomly with the backside of the axe. So, very first person of the, my lord, the affair is that, my lord, all the accused persons, my lord, assaulted Uttam with the blunt side of the axe, my lord. Then subsequently, my lord,
The Azahar was lodged in vernacular.
yes, ma'am.
Let us see.
I can read it. Ready? May I read it, my lord, vernacular? বিনীত নিবেদন হৈ যে যোৱা ইংৰাজী 1/9/2014 তাৰিখে ৰাতি 9টামান বজাত আমাৰ ঘৰৰ সন্মুখত ৰাস্তাৰ ওপৰত মই আৰু আমাৰ একে গাঁৱৰে শ্ৰী জলেশ্বৰ নাথ বয়স 30 বছৰ আৰু ৰবীন চন্দ্ৰ নাথ আৰু শ্ৰী বংকম চন্দ্ৰ নাথ আমি চাৰিজনে কাম কাজৰ বিষয়ে লৈ কথা পাতি থকা অৱস্থাত নিম্ন নাম উল্লেখ কৰা 1 পদকীয়গণে এখন চাইকেলত উঠি তীব্ৰ গতিত আৰু অসাৱধানতাত গৈ আমাক খুন্দা লগাই দিয়ে। আমি পদকীয়জনক 2-1 কথা কৈ গালি পাৰি থকাত পদকীয়জনে চাইকেলখন লৈ পলাই নিজৰ ঘৰলৈ গৈ উক্ত ঘটনাৰ বিষয় লৈ কেন্দ্ৰ কৰি অলপ পিছত পদকীয়জনে আৰু পদকীয়াগণক লগত লৈ দলবদ্ধ হৈ হাতত দা কুঠাৰ আৰু লোহাৰ ৰড লৈ হঠাৎ উক্ত ঠাইত গৈ আমাক প্ৰাণনাশৰ উদ্দেশ্যে আগুচি ধৰে। লোহাৰ ৰডেৰে যধে মধে মাৰধৰ কৰে। মোৰ আৰু ভাই উত্তম কুমাৰ নাথ বয়স 30 বছৰ আৰু উক্ত জলেশ্বৰ নাথ কেইজন প্ৰতিবেশী সহ বাধা দিয়াত পদকীয়গণে মোৰ উক্ত সৰু ভাই জনক কুঠাৰেৰে উল্টা পিঠি দি কোবাই যধে মধে জখম কৰে আৰু উক্ত জলেশ্বৰ নাথক লোহাৰ ৰডেৰে মাৰধৰ কৰি নানা ঠাইত আঘাত কৰে। আমি চিঞৰ বাখৰ কৰি কোনো মতে পদকীয়াগণৰ হাতৰ পৰা
That is okay. That line we are trying to see.
Yes.
The involvement of all the accused or one accused.
Yes.
But at the same time, we cannot lose sight of the fact that how many acts were involved or recovered or seized? Only one axe. Many persons cannot use one axe at the same time. And narration in the affair, as you know, is a brief in gist what has happened. The explanation will be done later. This may not be your main point. There will be other points.
Yes, my lord. The other points are also there, my lord. But only thing, my lord, okay, in the first, my lord.
And when 34 is there,
Yeah.
it will be difficult.
Whether, my lord, they had the common intention or not.
He had gone home and came back armed. It's not that they are coming.
Because there was a, my lord, quarrel was there. Admittedly, there was a
No,
quarrel.
quarrel was there, then he had gone home.
Yes,
Then he had come back with his father and the other brother.
immediately, my lord.
So, pre-concert, we cannot just say that pre-concert was not there. Pre-concert can be the case of the prosecution. Pre-concert, it's not of that they were coming together, suddenly a fight had happened.
My lord. But there was a
34 is
quarrel,
there.
my lord. There was a cross case, my lord. My father got injuries, my lord, for which there was a trial.
No,
Motion is-
on regarding the cross case, while your submission is that ideally the cross case should have been tried together. It has not been done. But in this case, why didn't you adduce evidence on the cross case?
That
Regarding the cross case, yes, there is a cross case. This is the case. Whether they are acquitted or convicted is a different matter.
my lord,
But at least we had also lost something against them. This is the case going. There is nothing
Yeah.
from your side.
but my lord, my submission before your lordship, my lord, whatever it is, my lord, there was a mistake, my lord. Either on the my lord part of the this accused person may not know, my lord.
No,
But-
but
but the
that-
council-
will that have so much of impact in the decision which we are supposed to take? We are only on the aspect of holding you guilty under 302.
My lord,
What are the requirements of 300? So is to bring in 302.
Yes.
You can give stress on that. What was the nature of the injury?
yes,
Number of the injuries?
yes, yes,
Which part of the body? And you have mentioned that in the PM report, there is nothing on the kidney part. He says kidney. PM does not say kidney. You can just highlight on those.
Yeah.
We'll try to see what can be done. Yes, next.
So, my lord, I would have, my lord, make submission on this, my lord. If we go to that, my lord, that, my lord, that 161 statement, my lord, Tushar was not, my lord, directly implicated in assaulting. That is, with the other accused also, my lord, they were there. Maybe, my lord, one X was there, my lord. As your lordship has pointed out, my lord.
See, we have also in other matters also, we are just pondering the use of the expression contradiction is will have a different connotation than an omission. Something which you omit to say and something which you contradict. You say something before here and something else before somebody else. There is a contradiction. But you don't say something before the police and say it may be an improvement. We are not saying that you will not have the opportunity to put across, confront him that you have not said before the police. The veracity will definitely be lowered, but it may not be a contradiction per se. Contradiction is something which contradicts with each other. I saw him hitting by a cricket bat. In the police statement, he said, no, I saw him hitting by a hockey stick.
But my submission.
No, just an example.
Yes, yes.
But he says, I saw him hitting. Did not say cricket bat. And in the police court, he said cricket bat. It may be an omission, but not a contradiction. There would be a fine difference. And here, a police statement, more or less, it's been the shadowy part of the tree that has not been so much elaborated.
And
but-
even, my lord, assault is also not.
Assault is stated.
No, my lord. PW were not stated.
Stated.
Photo have gone.
Stated, madam has read.
Puluka is supaya to comfort.
That's
Harus pintu ka supaya to the
Evidence of- evidence of-
tukar na hato to cholesterol. At kita sa mga
Yes.
161 we find, my lord, Podokyo gone. Gone mean, my lord, all it is.
41.
Because he is 160, because, my lord, the affair, my lord, immediately after the occurrence and incident has happened. He may not have stated there. But this 161 statement also, he has not specifically implicated that, my lord.
Then why was the other two accused given, one was given a very lesser penalty, punishment, and the one was acquitted? What basis?
My lord, in the judgment, we do not, my lord, see discussion of the cross-examination. Only on the basis of the, my lord, what is in examination in chief. This Tushar has been, my lord, given the, my lord, 302. Hmm? Hmm.
Yes, please proceed.
Joleshwar lot 161 it is there. Joleshwar lot's evidence, my lord.
Basanta and Jadeswar are injured witness.
Yes.
See, the occurrence as such appears to have been proved, but only your intention or knowledge to cause the death.
That is,
That-
I
that-
am on that. I will argue on that.
Kindly argue on that. I
Yeah.
think that will be.
Yes. Very good. So, my lord, whether it will be a case or, my lord, 302 or 304, part 1, part 2, my. In this case, my lord, if we are taking that, my lord, Tushar had given the, my lord, that fatal blow to Uttam. My lord, whatever evidence we have seen, my lord, there was some altercation was there, my lord. One side, my lord, first accused appellant was only present there, my lord. Subsequently, my lord, he went home. He came with his father and his, my lord, brother. And at that time, my lord, those persons, my lord, who were sitting from the, my lord, earlier point of time, they were still sitting there, my lord. And thereafter, this occurrence had taken place, my. What I am on, my lord, if, my lord, this appellant had the, my lord, the intention of causing the death of the, my lord, this
Uttam.
Uttam Nath, my lord, he was equipped with an, my lord, axe. Axe, my lord, one blunt side, another is sharp side. And, my lord, it is very categorically stated by the, my lord, the witnesses that the blunt side of the, my lord, axe was used in the assault. And, my lord, from the informant side also, my lord, there are 4 persons who are present there. And someone has also stated that, my lord, that because this rod and, my lord, axe had been, my lord, snatched.
Correct.
And it was, my lord, subsequently given to the police, my lord. So, my lord, if I had the intention to commit that, my lord, whether, my lord, I could have used the sub side of the, my lord, intention of causing the death of the, my lord, Uttam Nath, my lord. I could have very well used the, my lord, the sub side of the, my lord, the X, my lord. And, my lord, I could have, my lord, repeated that assault, my lord. But that was not done.
Yes.
And, my lord, coming to the, my lord, after he got injured, he was hospitalized. He was there for, my lord, 14 days. And subsequently, he died of, my lord, cardiorespiratory failure due to septicemia, my lord, because of the, my lord, those small intestine injuries, gut injuries. So whether, my lord, I had the intention of, my lord, committing the, my lord, murder. So by that, my lord, my argument, my lord, whether, my lord, that finding of the, my lord, learned code below, my lord, to convict me under section, my lord, 302 is not sustainable, my lord. And when there is a, my lord, cross case, my lord, I have got the judgment, I have got a certified copy of the judgment, my lordship can look at that, my lord, certified copy of a, my lord, giving judicial notice. Rightly or wrongly, my lord, the cross case was, my lord,
Difficult for us.
but I have obtained a certified copy, my lord. There, my lord, the father got the injuries, my lord. And for that reason, my lord, the always that case and cross cases are to be tried by the, my lord, the same court. But unfortunately, that was not
No,
done.
there is a procedure prescribed. Even in an appellate court, you can very well, you cannot just hand over a paper. We cannot. You could have adduced as an evidence.
That was not done.
Not done. No, here, even here,
Then,
even in the appellate court. That would be
That-
difficult for us. Had it been any other proceedings, yes. The proceedings strictly under the CRPC.
yes. But whether, my lord, this certified copy lordship could give judicial notice or not,
Difficult.
because public documents in the, my lord,
No, see,
Evidence
this
Act,
is
my
not a jail appeal. This is your appeal. You could have very well filed an application for placing this on record in the way provided.
So, my lord, even, my lord, in the evidence it has come, my lord, there is a cross case.
Where are the details of the cross case in the evidence?
Yes.
It's, you have just put a question in the cross examination.
PW, my lord, at page 21, lordship, find in the cross examination.
Where are the details? No details.
My lord, in the case number 21, my lord.
There's no details, nothing.
Prafullonath lost the case in PS against Basanta and me, alleging that we had assaulted them and had taken away 60,000 rupees.
Nothing more than that.
He
Case
says
was, case was registered, tried, what has happened, nothing.
Lordship, may I be given some time, my lord, to file an affidavit, my lord, to place this, my lord.
2020 matter. We have heard. You. We still think that we have other points.
My lord.
Which you have argued and you have touched.
Yeah.
You can place what are on 300 decisions you can place.
Yes, yes. I have got, my lord, some of the decisions, my lord. Okay. Okay. 1999.
You can give the citations to our court. You should have given Mr. Chaudhary.
My lord.
Should give at 10:30. What is this?
1999.
But still give it to our court master. We did not give the book. We'll take out the relevant pages. Hey, Harry, book. You mark the paragraph. मुझे पूछिलो first page to or paragraph thara. इसकी होने को उठे ना लगे सब मिसाइल. What is that? Ask you to save the people. Then just with the first page, they are not equipped with these pages. First page to have the citation and those pages which are recorded containing those paragraphs.
কাগজত লিখি দিম। Going to rely on decision of my Lord Supreme Court, AR 1999, Supreme Court 1428. A. Ramakrishnan,
1428.
1428. K. Ramakrishnan, Unithan appellant versus the state of Kerala. Hmm? 99.
A paragraph.
Paragraph, my Lord, 6, man. The question that remains for consideration is whether on the materials on record, can it be said that the appellant gave the blow on the deceased with the intention of causing murder of the deceased so as to be convicted under section 302 IPC. The eyewitnesses account of the 3 eyewitnesses is to the fact that when PW1 cried aloud, his sister was there, and at that point of time, his father, the deceased, came out, opening the door and asked as to why his son is being beaten up. And the appellant stabbed the deceased on his abdomen with a knife. Is it, my lord? There are 6, my lord, because I have got a decision of AIR, man. But the printout which has been brought out, my lord, that is
Yes, it's the same,
Active.
same.
same, my lord. The postmortem report of, has your lordship
Yes,
got it, my lord?
postmortem report of the deceased.
Yes, the
indicates-
postmortem report of the deceased indicates existence of a structured inside-on inverted T-shaped on the left side of the abdomen. The vertical limb was parallel to the midline 4 centimeter in length, and the horizontal limb is so and so. To the left of midline, and the junction of the 2 limbs were at the level of so and so. The wound entered the abdominal cavity. The Dr. PW4, who was working as tutor in surgery, medical college so and so, and was in the casualty on 17/4/85. In his evidence stated that this is that an incised wound about 4 centimeter long below the umbilicus left to the midline of the body on the part of the intestine protruding out, and it is the only injury. Here, my lord, that intestine had come out in this case. The doctor who conducted the autopsy, PW9, is evidence also stated, though there are 3 injuries on the deceased as per the postmortem report, but injury number 1 and 3 are surgical injuries, and injury number 2 is the inflicted injury. Thus, it is established beyond reasonable doubt the appellant had given 1 blow, but the blow no doubt was quite severe, as a result of which the intestine had protruded out. It is, however, crystal clear that the appellant had no animosity against the deceased, and he was involved because of the altercation with PW1. The scenario in which the appellant has been stated by the eyewitnesses to have been given 1 blow on the deceased, it is difficult for us to hold that he gave the blow in question either with the intention of causing murder of the deceased, or can have said to have the requisite knowledge that the death would otherwise to the inevitable result. In such a situation, even on accepting the prosecution case, we hold the accused did not commit the offense under section 302, but under section part 2 of the section 304 IPC. We accordingly set aside the conviction of the appellant under section 302 IPC and instead convict him under section 304 part 2. The incident is of the year 1985 and more than 13 years have elapsed. The accused is on bail pursuant to the order of this court dated so and so. Mr. Lalit appears so that he has already undergone of about 4 years in such circumstances for his conviction under section 304 part 2. We sentence him to the period already undergone. His conviction under section 324 IPC remains unaltered, but no separate sentence is being awarded. This is the my lord. Here also, my lord, some altercation was there and single blow was given. It was, my lord, that intestine had to, my lord, protruded out, my. Engagement was completed. 4 complete. 680. Now the decision, my lord, this is also in the, my lord, abdomen. That is why, my lord, I have taken this decision, my lord. 1994 supplementary Supreme Court cases 680. Ramaswamy versus State of Tamil Nadu.
Para?
Para, my lord, 5. Now coming to, as your lordship got it.
Yes.
Now coming to the nature of the offense, we find that the accused inflicted only one injury on the abdomen of the deceased. No doubt that even single injury hit in the ordinary course is sufficient. Attacks clause thirdly of section 300 result in conviction under section 302 IPC. In the instant case, the question is whether the accused intended to cause that injury. The doctor noticed one injury in the abdomen, but he opined that a complication may set in some cases. There may be complication from that it cannot be said that the person who received such injury would necessarily die. The doctor further opined that the complication may be after the injured is admitted in the hospital. In these circumstances, we find it difficult to hold that the accused intended to cause the particular injury. It is not a case where clause 30 of the section is attracted. Therefore, the offense committed will be culpable homicide not amounting to murder. Accordingly, we convict him under section 304 part 2, sentence him to suffer RI for 7 years. In our case also, my lord, this was, my lord, in the hospital for about 13 days, my lord. And he, my lord, developed septicemia, my lord. And my lord, ultimately he died of, my lord, cardiorespiratory failure. So considering that, my lord, I am praying that, my lord, lordship will kindly consider, my lord. Some other decisions are there, my lord. There, my lord, injuries were, my lord, on the head. There is also, my lord, that benefit of, my lord, that 3042 part 2 has been given. Headed to that 2012 on jail. Right. Another decision of our High Court, my lord, 2012 1 GLT 368.
SB.
This is a single bench, my lord. Here, my lord, trial court itself, my lord, one is under, my lord, 304 part 2. But only because, my lord, the injury is on the stomach, my lord, I have Daylight is
Anything else?
Lordship may not take into consideration because here, my lord, 323, 324 it is given.
Yes, madam.
Into.
Anything, any more decision? No.
Some decisions are there, those are on head, my lord. There also, my lord, the benefit of
Oh.
304 part 2 has been given.
You can come back in rejoinder if there's anything left out.
My lord.
Lordship, here, the instant case, your lordship, the accused persons are named in the FIR, my lord. The informant who happens to be the PW1, my lord, who is also an injured eyewitness, he has named the accused person, my lord, Tukhar Nath, and another, your lordship. And the injured person as well as the eyewitness, my lord, PW1 and 2, they have although there are little bit of omission here and there, my lord, but they have specifically named the accused person Tukhar Nath, my lord. And the part, your lordship, the accused person hit on the vital part of the victim, disease as a result of which he died. Although he did not die instantaneously, my lord, but he died after
Abdomen.
on the yes, on the abdomen. I'm sorry, lordship, on 39 he died, my lord. Although it's incident had taken place on 1/9/2014. So whether he could be held guilty under the exception or under 302, your lordship. My response submission is that he should be held guilty under section 302 of the Indian Penal Code. Because, your lordship, and on the day of incident, the PW1 and other prosecution witnesses were not armed, your lordship, whereas the accused person, along with the other accused person who have been acquitted and have been given other lordship and other conviction under sections of law, lordship, they were armed, your lordship. Whereas this is not, nothing has come up on evidence, lordship, that the prosecution witnesses were armed, your lordship. There are some altercation, there's some hit words were exchanged, my lord. But then thereafter, your lordship, after half an hour, the accused person came along with the weapon in hand, and thereafter it was attacked on the vital part of the victim, as a result of which he died, your lordship. And my responsible submission is that, my lord, half an hour is a period, your lordship, because during that period, the accused person had got sufficient time to think over or make a plan, as a result of which they came along with a weapon in hand and attacked the accused person, attacked the victim. So half an hour time was there. So they have got enough time. There was fooling period, and they, in order with an intention to cause grievous injury and cause death to the victim, your lordship, the weapon was used, and as a result of which they died. So on the 2 point, your lordship, so their case may not come under as an exception. And your lordship, there was an existing dispute, prior case was there, lordship. That
Exceptions means which exceptions are you
may
telling me?
not come, my lord.
No, which exceptions?
300 of whether you come under section. May not come. So
No, which of the
301, although they have not made the submission, my lord.
No.
Exception 1 to section
No, madam,
300.
see, the 5 exceptions are not the only cases where a case of 300 will be converted into anything else,
My lord.
304, 1 or 2.
My lord.
There may be other cases, culpable homicide not amounting to murder.
My lord.
The exceptions makes it not amounting to murder.
My
But
lord.
apart from the exception, even if it does not fall within the strict definition of 300,
My lord.
it may be a case of 299.
Maybe, my lord.
So if it's 299, 304 will come in. So exceptions, it's not essential that exceptions have to be there for a conviction under 304A part 1 or part 2.
My lord.
So
my
we are on on that part, whether the strict requirements 300 are met or are being established by the prosecution in this case.
My lord. And your lordship, as my learned friend has made it, has taken the plea, my lord,
Yes.
there was previous dispute, my lord,
Yes.
cross cases. His contention was flat on the plea raised by the accused appellant in 313, my lord. Your lordship may kindly have a look at the plea taken at page 58.
58.
Yes. During that time, I was having a fertilizer shop at Nitra Bazaar at Bashpari. On that day, I, along with my father, were returning from my shop at around 9 p.m. My father was at home distance behind me. On reaching in front of the house of Bakantonath, I was assaulted with his clothes by Bakantonath, Jaleswar and 3-4 others. They took away rupees 60,000 from my pocket. So this 60,000, lordship, although my learned senior friend has taken the plea, but because of the 60,000, there was some dispute. There is no plea has been taken by him. There was another plea which has been taken by him. That they took away 60,000 from my pocket. On hearing my scream, my father also reached there. They also attacked my father. I managed to escape from there and went to my brother's Tilok's shop. Tilok and I came back there and saw my father was confined inside the house of Bokonto. Village people gathered there, and on their intervention, my father was released. My father sustained injuries as we brought him to Bongaigaon Civil Hospital. My father was admitted for 1 night there. I did not attack Uttam with X. We are innocent, falsely implicated. We filed a case against them. We gave evidence in the case. I do not know what happened to the case. So regarding the injury caused to his father, nothing is there, your lordship. No evidence is brought in by the defense.
Yes.
Lordship, and regarding the cause of injury, my lord, lordship may kindly have a look at page 96. Whose position character,
96.
the postmortem report. A longitudinal scar present with stitch over abdomen, laparotomy wound 10 cm long about, a small 2 cm so scar present on right side of abdomen drainage. Then your lordship, the cause of death at page 99. In my opinion, the cause of death is due to cardiorespiratory failure, due to septicemic shock, due to multiple gut issues. Because of the injury received by the victim from the attack caused by the accused appellant, your lordship, the victim died. Although after 13 days, my lord, but it was due to septicemic shock due to multiple gut issues. So the vital parts of lordship regarding the when a deceased died after 13, 14 days or after a certain period, lordship, may I refer one citation?
Please.
The 2023 11 SCC 320.
2023.
Lordship, I cannot make the citation.
No, give the citation. We'll have it.
2023 11 SCC 320.
Name.
Prasad Pradhan and others for the state of Chhattisgarh.
Paragraph.
Paragraph 50, para 24 and 25.
Very good. Very good. Yes, what has been laid down?
Lordship, during para 25, during the hearing, the appellant counsel had urged that Vrindavan died 20 days after the attack, and the lapse of such a time shows that the injuries were not sufficient to cause death in the ordinary course of nature. On this aspect, there are several judgments which emphasize that such a lapse in time would not per se constitute a determinative factor as to diminish the offender's liability from the offense of murder to that of culpable homicide not amounting to murder. In Om Prakash versus State of Punjab, certain one has been reference has been given. Fortnight after the attack, and in Sudarshan Kumar, the death occurred 12 days after the attack. There can be no stereotypical assumption or formula that where death occurs after a lapse of some time, the injuries which might have caused the death, the offense is one of culpable homicide. Every case has a unique fact situation. However, what is important is the nature of injury, whether it is sufficient in the ordinary course of to lead the death. The adequacy or otherwise in medical attention is not a relevant factor in this case because the doctor who conducted the postmortem clearly deposed the death was caused due to cardiorespiratory failure as a result of injuries inflicted upon the deceased. Thus, the injuries and the death were closely and directly linked. Then another citation regarding the cooling period, I'll be referring, my lord. 2015, 2015, 1 STC 286.
On SCC 286.
286. Para 13, 14,
Name
15. On this one, my lord,
DB.
BD Kunte versus Union of India. I'll be relying on para 13, 14, 16, 17. Here, Nanavati's case has also been cited.
Yes, please read.
Para 13. All that the evidence proves is that after the said incident, the appellant was seen crying and depressed, and when asked by his colleagues, he is said to have narrated his tale of humiliation at the hands of the deceased. There is no evidence to prove that after the incident aforementioned, the appellant had continued to suffer a prolonged spell of grave provocation. By their nature, such provocation, even when sudden and grave, full of with passage of time, often lapsing into what would become a motive for taking revenge whenever an opportunity arises. That appears to have happened in the present case also, for the appellant's version is that he and his colleagues had planned to avenge the humiliation by beating up the deceased in the evening when they all assembled near the water heating point. That apart, the appellant attended to his normal duty during the time, and after the evening dinner went to perform his guard duty at 21 hours. All these circumstances do not betray any signs of grave leave alone, grave and sudden provocation to have continued haunting the appellant and disturbing his mental equilibrium or depriving him of self-control. That is an essential attribute of grave and sudden provocation to qualify as a mitigating factor under Exception 1 to Section 300 of the Indian Penal Code. It was contended by Mr. Sishodia that although between the incident that happened at noon and shooting at the deceased at 21:30 hours were separated by nearly 7 hours interval, the nature of the provocation continued to be grave within the meaning of Exception 1 to Section 300 in the Indian Penal Code. We find it difficult to accept this submission. Grave provocation within the meaning of Exception 1 is a provocation where judgment and reason take leave of the offender and violent passion takes over. Provocation has been defined by Oxford Dictionary as an action, insult, etc. that is likely to provoke physical retaliation. The term grave only adds an element of virulent intensity to what is otherwise likely to provoke retaliation. In Holmes versus Director of Public Prosecution, 1946, AC 588, provocation has been explained as under. The whole doctrine relating to provocation depends on the facts that it caused or may causes a sudden and temporary loss of self-control, where a malice, which is the formation of an intention to kill or inflict grievous bodily harm, is negated. Consequently, where the provocation inspires an actual intention to kill or to inflict grievous bodily harm, the doctrine that provocation may reduce murder to manslaughter seldom applies. The argument that the incident that took place around noon on that day was a grave provocation that continued to provoke the appellant right through the day till 9:30 evening, and the appellant shot the deceased, does not therefore appeal to us, not only because the appellant had settled for a lesser act of retaliation like beating of the deceased and in the evening by him and his colleagues when they assembled near the water heating point, but also because the appellant had performed his normal duties during the daytime and even in the evening, except that he and some of his colleagues appear to have planned beating up the deceased. In court was this court was in K. M. Nanavati versus State of Maharashtra, AR 1962 SC 605, dealing with a somewhat similar question. In that case, the wife of the accused had confessed her illicit intimacy with the deceased, and the deceased was not present. The prosecution case has proved as a trial was that after the confession of the wife, the accused had driven her and the children to the cinema and
This is
left them
mainly
there.
on the aspect of this provocation,
My lord.
not may not be strictly applicable in this case. You say that they had gone home, came after half an hour, but they have not even taken the plea
That
of.
plea that happened. So, I'll leave it to your lordship. And considering the fact and situation, even if the victim died after 12, 13 days,
That you have submitted Prasad
my
Pradhan,
lord,
25.
lordship may take into account that factor and affirm the conviction. Also, lordship, one more plea, my lord. I should, as a state council, I should not say, but lordship may take into account his age, my lord, 21 years age. That factor, lordship may take.
Yes, okay. Anything you'd like to
That
add?
fellow, that 60,000 rupees is not a mild plea and all, because that was the cross case. There was no grievances that because of that 60,000 some mild grievance was. Because on that day, mild, our cross case was that mild that assaulted and taken away 60,000. And because of that, mild, considering the whole facts and circumstances of the case, and considering his age, mild, I am praying before your lordship, my lord, that it may not be a case of my lord 302, my lord. He did not have the intention to cause the death, my lord. And my lord, at the night time of occurrence, my lord, seeing though it has not come, my lord, that his father has been assaulted. This young boy might have given one blow, my lord, which had become. And that also, my lord, at the blunt side of the my lord. Act. And he might not have the knowledge that, my lord, that blow, my lord, could cut the, my lord, small intestine, causing injury.
But I'm repeating you. নাছিলে জন্ম বিচাৰ শুকান আছে নেকি শুকান আহিছিল তেওঁ থকাৰ কাৰণে দিয়া নাছিল
I'm obliged.
Item number 9.
11.
No, no.
Just a minute, let us first dictate this. Heard 3 B.M. Chaudhary, Leonard counsel for the appellant. Also heard Ms. D. Huya, Leonard APP Assam. Hearing is concluded, judgment is reserved.
Obliged.
ঠিক আছে একটু আসুন ঘরকে রেকর্ড ওয়াজ এগুলো রেকর্ড হলো Yes.
May please, my lord. My lord, item number 9, I was appointed to the amicus.
Yes.
However, actually, that was after the previous amicus elevated. In that transition period, my lord, like
paper book has been misplaced. I apologize for the same. My lord, I just need some time to procure the paper book. Oh, I can do that.
I'll give my copy to him. He'll give
I
it to
will
you.
make a xerox. How many PW? I think less, 7 or
Seven.
7.
Seven.
6.
Six
Yes.
were there. I
Oh,
don't know.
okay. Your A Sandillo
Yes.
on the prayer of 3 A Sandillo Leonard Amicus. Matter is John.
Hmm.
By 2 weeks.
Well, really?
Miss B. Leonard APP is present.
Right.
Madam Fukan, your matter, there was a mention made because you are not informed, so we did not. We will adjourn. It was mentioned on behalf of Mr. A. Ahmed, okay? Item number 11, on a request made on behalf of Sri A. Ahmed Leonard Amicus Curie, matter is adjourned. Will be listed after 2 weeks. Miss B. Leonard APP Assam and Ms. K. Fukan Leonard Council for responded to are present.
Only one matter is
Mr.
right.
Das, NJ Das,
take up after a week.
he might like to do. He was there, ready with book.
And get us.
NJ Das, he was there. We'll sit at 2 o'clock. If you want some time, we'll consider. You can, yes. Go.
We will.